Thank you, everyone. Please be seated. Before we get going, it's my understanding we have some students here from Marshalltown. Is that right? Raise your hand. What grades do you guys represent? Oh, high schoolers. All right. You had to set the stage for me. My colleagues know why I asked. We're going to tell you where we went to high school. Everybody has to have a high school. So I'm Susie Christensen, the chief, and I graduated from Harlan High School in 1980. We're the Harlan Cyclones.
Tom Waterman, graduated in 1977 from Bettendorf High School, Bettendorf, Iowa, the Bulldogs.
And I graduated from Lexington High in Lexington, Massachusetts in 1974. And we are, you have the Revolutionary War, we're the Minutemen.
Christopher McDonald, I graduated from Des Moines Lincoln High School, class of '92, the Rail Splitters.
Dana Oxley, I graduated in 1986 from what was then Greenfield Tigers. It is now Nottoway Valley Wolverines.
I'm Matt McDermott. I graduated from Kemper Catholic in Carroll in 1996.
I'm David May. I graduated from Kirksville High School in Kirksville, Missouri. Go Tigers.
And when you give your talk, you need to tell us where you went to high school so the students know you have to go to high school at least. All right. First case today is State of Iowa versus Tolbert, and it looks like both parties are ready. Mr. Kragnes, you may begin.
May it please the court, counsel. I'm Chris Kragnes. I graduated from Bismarck Century High School in Bismarck, North Dakota. We were the Patriots. So with that, Your Honors, provocation belongs inside the murder analysis, not after it. Your Honors, this case has three particular issues involved in it for today's purposes. One dealing with instructions on voluntary manslaughter, one on a mistrial request, one on a conflict issue. I'll start with a brief rendition of the facts, and with the court's permission, I'll focus most of my time related to issue number one. Of course, I'm hopefully prepared to answer any questions that you may have related to issues number two and issues number three. Related to the facts of this case, Your Honors, this was a homicide case out of Scott County, Iowa. Sherral Tolbert was charged with first-degree murder for the shooting death of LaVonta Baker. Facts of the case were fairly straightforward related to that. Incident was caught on video. Most of the issues that, as we're addressing today, are fairly procedural in nature, and throughout the course of trial, a contentious and issue that was raised was whether or not this was done at provocation or serious provocation. Mr. Tolbert, in fact, testified in his defense, indicated what the provocation was in his mind. Tolbert requested various jury instructions, asked for various modifications to instructions, asked for different alterations to the court's instructions at that time, all related to, yes.
That, as I understand it, that Mr. Baker, some 3 months before, had been involved in a shooting at the house where Tolbert's family lived. Is that the provocation? Is that right?
Actual provocation, Your Honor. That's a piece of what went into Mr. Tolbert's provocation that particular day. Mr. Tolbert's provocation that particular day was seeing Mr. Baker on a street as they passed each other in the car. I believe the testimony was that he saw Mr. Baker do something, an indication, and saw something in his hand, and the direction that he was heading was towards Mr. Tolbert's grandmother's house. Frankly, the only mother Mr. Tolbert has known in his lifetime. And that's what started that provocation that particular day. So the event in and of itself, no, but did it play a part in Mr. Tolbert's thinking? Yes, Your Honor. And so related to that particular circumstance, we need to go no further than just looking at what the legislature has done with 707.4. The legislature has written that for voluntary manslaughter to occur, it is a death under circumstances that would otherwise be murder. This textual choice means provocation belongs inside that murder analysis. And yes?
And on the instruction, I think the briefings called it an acquittal first instruction. I think maybe that's not wholly accurate in the sense that I think what you're saying is that, and correct me if I'm wrong, that there needs to be a transition sentence somewhere in that instruction. So you still could have an acquittal first instruction, but then say, if you find murder, then you also need to consider manslaughter. Is that lack of a transition sentence that you're concerned about, really, not the acquittal first part of it?
That would be, Justice McDonald, fairly accurate in terms of what we're arguing, and admittedly, I'll be the first to acknowledge the record we made at the trial court level, while ultimately ended up, I think, being thorough enough, it did move around. Our original instruction asked for them to consider voluntary manslaughter, and in fact, it required them to consider it, and we had placed that instruction before murder 1 and murder 2. In an alternative, we then asked to at least have circumstances that would otherwise be murder included in the voluntary manslaughter instruction. And then I believe in as we've briefed and within the record itself, we did also offer the suggestion that in the marshalling instruction, it could be included that if they found the elements of murder met, they may consider the other lesser included offenses. So I guess the best way for me to answer your question is in circumstances of murder and voluntary manslaughter, I'm not sure acquittal first works, but if acquittal first is going to be maintained, then yes, we would be requesting that essentially a mitigation element or something of that effect.
In other jurisdictions that still have the acquittal first rule, meaning the jury has to start with the most serious charge first, but then it includes transition language to the manslaughter instruction. And then there are some jurisdictions that are not acquittal first, and they just tell the jury, you kind of look at all the instructions as a whole and settle on the charge that you think is appropriate. So I think you could have them both. I just want to understand what your argument is.
I would concede that you could have them both. And in fact, in either the marshalling instruction for murder in the first degree or murder in the second degree, you could have language, and forgive me, I'm thinking on the fly, but all the elements have been met, and unless you find this was done by serious provocation as defined in instruction, whatever. And I think that would be appropriate, and I think that would still keep the murder first.
Think of our decision in State versus Taylor in 1990. We said that a key distinction between the voluntary manslaughter and murder is that with voluntary manslaughter, there's an absence of malice. So if there's if that's the case, you really can't convict someone or find someone has met all the elements of murder and yet also find that they've met the elements of voluntary manslaughter. Taylor, we seem to say no, that's not the case.
Justice, I would respond to that with, while I don't believe necessarily that State v. Soretti, I guess, overturned Taylor, but in State v. Soretti, the court made it very clear that in recognizing the circumstances that would otherwise be murder, that it applied both to murder 1 and murder 2, and that would allow for looking at voluntary manslaughter. Additionally, if you go to the historical component,
The case about the one homicide rule or something like that. I was on it, and I don't remember it very well, but I think that was the issue we were dealing with. Am I correct?
Case involving the one homicide rule, involving whether or not an elements test was met. However, in getting to that point and showing that in fact that the element test wasn't met, the distinction was made that you can commit murder 2 or absent specific intent, and you can have within murder 1 different elements, but the court indicated in Soretti that's why it was different from voluntary manslaughter, in that voluntary manslaughter means in circumstances that would otherwise be murder.
Taylor says, voluntary manslaughter means there's an absence of malice. You have to have malice for either murder 1 or murder 2. So there is, if the jury finds someone guilty of murder 1, or in this case murder 2, they've found malice, so they couldn't have found voluntary manslaughter.
Judge, I would respectfully disagree, and I would disagree with that, namely because the actual intent of the legislature, taking the words as they have written them, as they are meaning, is in circumstances that would otherwise be murder.
Included offense. So if as you say, voluntary manslaughter means all the elements of murder plus an additional finding that it was committed under serious provocation, that's not a lesser included offense. That's additional elements.
Actually, I would disagree. It's a mitigation, Your Honor. It is a finding all of the elements of murder 1 or murder 2 and finding that serious provocation did not exist.
And I understand what you're saying, but it's still not what we would consider a lesser included offense. It's not. It doesn't have some elements that are within the elements of murder. It has an additional element. Now, whether that's whatever we want to call it, it's not a lesser included offense, though. And the legislature says right in the statute it is a lesser included offense. So.
Absolutely is a lesser included offense, and I think the legislature's intent in writing the statute as they did was to deal with some of the common law definition of voluntary manslaughter before 1976, the common law definitions being, avoiding specific intent, perhaps the actual malice, and the legislature specifically included in the 1976 rendition, and actually in 76, I believe they said in circumstances that would otherwise be homicide, and then in 1977, they changed it to circumstances that would otherwise be murder.
Try to reconcile our older case law and the statutory text. Would we have to overrule the Taylor decision? I think maybe one way you could conceive of it is maybe the provocation is an excuse for the malice, right? Like you could, in those circumstances, you were provoked to undertake this act. Malice is, we said, a state of mind of hatred, ill will, intent to injure. But we're excusing that element because of the provocation. Otherwise, it seems like we have to do some work because the text clearly says that it's a lesser included offense.
Absolutely, and I do believe that's where it falls into what our argument is, that it relates to mitigation and I don't want to use the word justification, a reason for. And again, reading the text of 707.4, there's no other way to read that text. It effectively is saying you did A, B, C, and D, or A, B, C, depending on murder 1 or murder 2, but you did it as a result of this serious provocation. So I don't believe you'd have to overrule Taylor related to actual malice. I believe what is being stated here is if all of these elements are met, but it was a result of this, which is what 707.4 states, that is voluntary manslaughter.
You to instruction number 6, which says, you must consider all of the instructions together. No single instruction includes all the applicable law. That requires a jury to read instructions 1 through 52, I think, here. They're going to get to it. Why does the ordering matter, and why does it matter that there isn't a transition statement here? If we assume, as we do, that jurors read all instructions.
And that assumption, Justice McDermott, goes to the heart of our argument. And I certainly appreciate what instruction number 6 says, the instruction related to reading all of the instructions and taking them as a whole. However, I'm sure this court can see the contradiction that is there. If you go to the 2 marshalling instructions that relate to murder 1 and murder 2, they have a stop. It's a plain and simple stop.
Judge read the instructions out loud for a long time before the jury went to the jury room. I think there's an assumption that they read all the instructions, and didn't the trial judge also read the instructions to them out loud, which would have included anything beyond 30. It would have also included the instruction at issue, manslaughter.
You did, Judge. However, that then builds in its own conflict within those instructions. In instruction number 6, you're telling the jurors, take these as a whole, listen to what I've read to you, and we make an assumption that the jurors do that. We make an assumption that jurors follow the instructions that they're given. If we're going to make that assumption related to instruction number 6 and reading them as a whole, we need to make that assumption as it relates to the 2 marshaling instructions under Murder 1 and Murder 2, which are, if you find these elements, boom, the defendant's guilty. That's not what the legislature intended in the writing of 707.4. That's not what the plain meaning of the text in 707.4 is either.
Don't we get into the nullification question, right? Once the jurors find that those elements have been met, at that point, a different instruction would be unwinding that finding, right? Asking the jurors to essentially nullify their conviction under Murder 1 or Murder 2.
Respectfully, I would disagree. It's not a question of nullification, it's a question of mitigation. The intention of that statute, the intention of voluntary manslaughter in Iowa is, if you have committed this crime under this circumstance, it is now voluntary manslaughter. So it's not nullification, Your Honor. It is simply mitigation. A transition statement, something that allows and, more importantly, instructs the jurors that this is what our law is, allows us to get there.
Before you step away, were you able to make the provocation argument in closing and show the jury the instruction that wasn't in the sequence you preferred, but it was included in the packet?
Thank you. How do I put this in I guess, the politest way? I'm very glad you asked that question, Justice Waterman. This is an extreme frustration related to defense counsel. And how many times we hear, oh, yes, you know, I believe that's an accurate statement of the law. I believe, yeah, you can even argue that. That's fine, you can argue that. But I'm not going to give that instruction. Respectfully, it does not have the same weight and power that an instruction that, more importantly, follows the law and is required to be given by the law as simply arguing it. I don't get the ability to say, this is what it is, because it's not on paper. Thank you.
Banta?
Madam Chief Justice, and may it please the court. Class of 2010, Olympus High School in Salt Lake City, go Titans. I think the key point here is this. These jury instructions gave the jury an opportunity to decide whether Tolbert shot Levanta Baker dead because of passion or because of malice. Those instructions raised that question, and the jury answered it by rendering a verdict of guilty for murder in the second degree. I agree as a general matter that the jury instructions for voluntary manslaughter should have some gateway to consider the question of passion alongside the instructions for murder. The instructions here did that. I would point the court to instruction number 24. In the 4th paragraph of that instruction, there are 5 paragraphs total. They're defining malice, and the 4th paragraph in particular says that malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. With that instruction, which again accompanied the murder in the first degree instructions, it was instruction number 24, instructions 22 through 29 covered murder in the first degree, instruction 30 covered murder in the second degree. This instruction was given alongside murder. It defined passion, it distinguished passion from malice, and that gives a gateway for the jury to think about passion at the stage of murder, and that is what the statute requires. I agree with that. This gateway may not be as big as Mr. Tolbert likes. It may not be as expansive as the one that he, in the state's view, wrongfully introduced during closing arguments. but it is enough, and it follows the statute.
So if you looked at the statute, let me back up. If the jury found it was heat of passion and not malice, then it wouldn't be murder, right?
Yes, passion negates malice.
If you look at the statute, though, it says voluntary manslaughter occurs when that person causes the death of another under circumstances which would otherwise be murder if the person causing the death acts solely as a result of passion, blah, 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 blah. So it seems like, as the defendant is reading this, there has to be a finding of murder before you even get to voluntary manslaughter. So maybe our instructions or our case law are inconsistent with the text of the statute.
That the instructions or the case law is inconsistent with the statute. I think the instructions are implementing the statute. And you read the circumstances clause or the otherwise clause, I call it one or two of those things. You read that clause in connection with subsection 3, which clearly says that the legislature wants voluntary manslaughter to be a lesser included offense of murder. When you read those two together, you get a situation where the instructions need to, and this is in fact what they do, say consider murder. If murder is there, then you have found malice, and passion negates malice. Those two cannot coexist. So you've considered voluntary manslaughter. If, however, you're considering murder, and the jury thinks, well, this isn't murder, then the next question, the circumstances clause in subsection 1, in connection with subsection 3, would say, ask why it's not murder. And if the answer is passion and provocation coupled with insufficient time to cool off, then you have voluntary manslaughter. That's what the statute's doing, and that's what these instructions set out. They follow that same structure.
741, the way you're describing it is, it should say in circumstances which are a homicide. I mean, the jury has to find malice for it to be murder. I mean, that's a prerequisite of the statute, right? So they have to find malice before they even get to 70741.
Your Honor, the jury will be talking about malice, and in the context of first-degree murder and in the context of second-degree murder. In the course of that deliberation, the jury could easily conclude there is no malice here because we're looking at instruction 24, which defines malice. We're looking at the 4th paragraph, and we're saying, no, there isn't malice because there's passion. And in that instance, they will proceed to voluntary manslaughter, and they'll continue, they'll look for provocation. They've already established passion. They'll look at time to cool off, and then they'll say, all right, is the reason we said this is not murder solely because of passion and provocation? The word solely there is crucial. That's the linchpin for my claim that passion negates malice. That claim is supported in the case law, as Justice Mansfield pointed out. Voluntary manslaughter under section 707.4 amounts to murder without the ingredient of malice. That's Taylor 452 Northwest 2nd at 607. That is citing a North Carolina case that states malice is usually negatived in the voluntary manslaughter context by heat of passion, which must be aroused by adequate provocation. Additionally, in State versus Soretti, this court used the word negated when talking about the mens rea for murder in the context of voluntary manslaughter. The mens rea for murder is negated by voluntary manslaughter because passion negates malice. And this is a key point. I want to illustrate it with math, with an equation. If you're asking what voluntary manslaughter is, this is the formula. I'll tell you actually what the formula is not first. Voluntary manslaughter is not murder plus passion plus provocation. That's wrong. Voluntary manslaughter equals murder minus malice plus passion plus provocation. That's the correct thing. That's what the statute's doing. When you use that formula, I think you're following the statute. You're particularly following that important word solely. When you're also looking at the circumstances clause, it's really important to think to sort of fill in the last part, when we're saying circumstances that would otherwise be murder, it helps to say otherwise, but for what reason? Circumstances that would otherwise be murder, but for provocation and passion. That's what subsection 1 is doing. And when you leave off that but for provocation and passion part, I think the circumstances clause is really confusing. And you can throw it out there and it can mean all sorts of things. But when you read all of subsection 1, it's so plain that what it's saying is circumstances which would otherwise be murder, except but for passion and provocation.
By saying you think there should be a transition of some sort, and that was met here.
Your Honor, a gateway. Yeah.
And you think it was in that instruction, maybe this instruction as a whole was correct, but would it be wrong in the murder marshaling instruction to include a sentence that said something like, you should consider first whether or not the defendant is guilty of first-degree murder. If you so find, then you should also consider whether that charge should be reduced to manslaughter based on provocation, and make the gateway more explicit so the jury doesn't have to hunt to paragraph 4 of the malice definition as they're going through their deliberation. Why would that be wrong?
Not appropriate and it's not necessary. I understand the defense bar would like a bigger gateway, but they're not entitled to it. The statute doesn't require it. The current instructions work and adequately accomplish this task.
It's statement of the law, what I just read.
I'm not sure if it's an accurate statement of the law because I think it encourages the jury to chew its food twice. And when you do that, when you're telling the jury, the instructions as is adequately instruct on voluntary manslaughter for the reasons I've outlined. And when you add that on top of what currently exists, you are encouraging the jury to chew its food twice, and that is inappropriate because of Justice McDermott's point. It invites jury nullification. It's putting a thumb on the scale. It's telling the jury, render a verdict. The evidence is there. The case is proven beyond a reasonable doubt, but go back and think about it again. That encourages, that's the functional equivalent of nullification.
2, it says if the state's proved all these elements, the defendant is guilty of murder in the first degree. It doesn't tell the jury to do anything. But then it says if the state has failed to prove these elements, then consider instruction number 30 on second degree murder. So, I mean, at least I put myself in the position of a juror. I think I would stop if I found first degree murder after instruction number 22, and I would only go on to instruction 30 if I found the defendant was not guilty of first degree murder. So sequentially, it doesn't seem like they're chewing the food twice, as you put it.
Justice McDermott's point about instruction number 6 and the Chief Justice's point about the instructions being read to the jury more broadly alleviate that concern. This is where those 2 points come in. These instructions, as all instructions are, were read to the jury. That's in the record, docket 637 at 609, lines 17 to 20. And Tolbert himself read these instructions to the jury. I want to highlight briefly the closing arguments. I'll read what happened during closing arguments. This is from defense counsel, trial counsel. The state must prove all of the following elements of the offense of voluntary manslaughter. Now, I'm going to argue some things that you just don't necessarily read there. And if I'm wrong, I'm sure somebody will tell me and we will find out. On or about the 25th day of October 2020, the defendant shot Banta Baker. Voluntary manslaughter, ladies and gentlemen. It is that, but it's actually more. It's more specific. Voluntary manslaughter is actually murder. Voluntary manslaughter is circumstances that would otherwise be considered murder. Oh, I'm not hearing that I'm wrong. You can read one that way. Does it sound terrible to say it's murder with an excuse, a reason? But this is the law we have. We talked about this back in jury selection. That is an inaccurate statement of the law. It is not true that voluntary manslaughter is actually murder.
As I understand it now, because you're making it here, I didn't totally pick up on it in the brief, is that
21 of my brief, quite a lot here.
Instruction 24 which the jury has to get to no matter what, because it's part of the murder instructions, contrasts malice and passion. And so they have to find an absence of passion and they have to find malice, which Taylor says are mutually exclusive in order to convict of murder. And so then what we're left with, the one thing that's still hanging out there is this indication the legislature's given us that maybe we haven't taken seriously enough, that voluntary manslaughter involves circumstances that would otherwise be murder. How do we read that language? What does the legislature mean by that?
Doing three things when it's writing the circumstances clause. One, it's clarifying that voluntary manslaughter is an intentional homicide. Without the circumstances clause, it would not be obvious that voluntary manslaughter must be intentional as opposed to being an accident. In addition,
Element of the crime. You're saying that it's an element of the crime that it must be otherwise. It otherwise be murder is an element of voluntary manslaughter.
I'm not sure if I'm saying that either way.
State to prove, in other words. If it was just if it was an auto accident where it looked like it was just an accident and somebody died, you couldn't charge it, right?
The answer is the state has the burden to prove malice aforethought, and malice aforethought is a semantically overloaded term. Sometimes we mean the morally blameworthy mental state, and sometimes we're talking about the intentionality. Really, both of those things are wrapped up in the term malice aforethought or mens rea when we're talking about homicides. My point is that passion negates malice, and of course, in connection with proving malice, the state would need to improve intentionality, in addition to malice, which is a fixed design to injure an unlawful purpose. It can also be hatred. That's sufficient, but not necessary. But two other things that the circumstances clause is doing that is helpful is it's explaining that voluntary manslaughter is not murder, that it's intentional, and that it's also bookending the if clause. Everything that comes after the circumstances clause, if, and then it talks about passion, provocation, inadequate time to cool off. It's bookending that whole conversation in a way that's really clarifying what the statute means and what it's doing.
Your time's almost up. You're not arguing harmless error, are you? Because, after watching the video of the shooting itself, one is maybe left with the impression it looks, I wasn't at the trial, but it looks more like an execution than a homicide under the heat of passion of an immediate provocation. You're not arguing that, though.
This is permission. I'll answer your question, Your Honor. The state does ask this court sua sponte to consider harmless error because any instructional error did not prejudice Tolbert. The evidence for provocation here is so razor thin. Tolbert also had the opportunity, as I outlined in reading the closing argument, he had the opportunity to get in the instruction that he wanted to the jury, even though it was inappropriate to do so. That, I think, really strengthens the case here for the state to ask for harmless error. The three factors that this court considers when evaluating sua sponte harmless error all favor the state here. This record is relatively short for a murder trial. This is, again, very thin case, as you outlined, for provocation. And if the court orders a new trial, the jury would likely reach the same result and perhaps convict on first-degree murder. Thank you.
May I please?
Didn't the jury acquit on first degree? So that's off the table now, right? Okay.
Rendered the lesser included of second degree, Your Honor. As I was trial counsel in this matter, it's not often I'm told that I've been given or been giving inaccurate statements of the law, but I'll accept that as it is. The practical reality, though, is that it wasn't my statement that was inaccurate then. In Soretti, this court said, we acknowledge that voluntary manslaughter can be committed under circumstances which would otherwise be first-degree murder. It also then went on to say that it could be committed under circumstances that would, yes.
Where I keep kind of getting tripped up is the word otherwise, that it would be murder, it otherwise would be murder, but it was done in the heat of passion. That doesn't seem like that seems like a pretty straightforward notion. And it seems like these instructions would meet that. Isn't the key word otherwise here?
Well, the key word is, there's a couple key words, otherwise and murder. The effect, Your Honor, is when we look at the rest of the statute and we get into solely as the result of sudden, violent, irresistible passion, we have a circumstance where we're never giving the jury the opportunity to get to that point. They're not being told that if you find that this was murder, first or second degree.
Let's respond to the state's argument then on instruction 24, paragraph 4.
Paragraph 4 of instruction 24, bear with me one second.
Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. So doesn't that kind of, as the state argues, isn't that enough of a gateway?
I don't believe so, Your Honor, because if we look at 707.4 and that definition, solely as the result of sudden, violent, and irresistible passion resulting from serious provocation sufficient to excite such passion, and then it continues to go on. There's more to that than simply what is placed in on instruction number 24, paragraph 4. And we're talking about that provocation element. We're not talking in that particular instruction, if I'm remembering how it was read, any mention at any point in time of provocation. And effectively, we have a requirement. That requirement is we have to instruct juries properly. And again, I would be the first to concede, as Justice McDonald has pointed out, in terms of maybe a transition sentence within the marshalling instruction. Probably could have been more artfully done at the trial level, but I think we tried to present the court with every option available to mitigate what the court was attempting to do.
Interrupt. Yeah. So the state's conceding error preservation, but we can bring it up. And so I want to talk to you a little bit about what happened at the jury instruction conference. It looks like the defense took the position that there was a instruction submitted, but you're modifying the request so that it's instead of making it so that the jury must consider it, you were asking for an instruction that said they may consider, and that was the more accurate reflection of the law. Is that correct? Is that the position taken then?
Was taken at that time related to our specific, and I believe it was our proposed instruction 23. Also, though, at the conference and in our objections and our discussion, we also asked, and this is in our brief on page 16, if the state has proved all of the elements, the defendant is guilty of murder in the first degree. However, the jury may consider all other lesser includeds before rendering their final decision. That is something that we put forth for an opportunity, again, to mitigate or preserve the issue of, look, you need to look to other things.
Got it right that it's a may consider?
Yes.
Okay.
Yes, Your Honor. And I see my time is up unless there's other questions. Okay.
This harmless error.
Not harmless error, Your Honor. First of all, error is presumed, when a jury is not instructed properly. Second, even though Justice Mansfield discussed the video, that's not the whole story. And as we've learned in many cases, parts of videos don't mean the whole story. There's things that occur off video, before video, and things of that nature. And in fact, under our contention, that if it's circumstances that otherwise would be murder, if they're not told to consider that, you can't presume that this was harmless.
On instruction 24, paragraph 4, I'm wondering if maybe that's not a correct statement of the law given our 707-4 instruction. So if you look at the top, the first paragraph says malice is a state of mind. The definition of malice is a state of mind which leads one to intentionally do a wrongful act, the injury of another, out of actual hatred or with an evil or unlawful purpose. I think you could have that state of mind as a result of a serious enough provocation, which would be the voluntary manslaughter. And maybe we just need to clean out or clean up the heat of passion language.
Respectfully, Justice McDonald, that's what Code Section 704.1 says. That's what it means, is that because of that serious provocation, we're mitigating all of these other steps that you did and that evil intent, that unlawful purpose, because it was seriously provoked.
Can I follow up on that? So do you disagree with the state's formula that voluntary manslaughter is murder minus malice plus passion and provocation? Is it your contention that malice is still there?
Not just my contention, Justice Oxley, I believe it's this court's contention in prior cases as well. However, the equation that I would use is that voluntary manslaughter equals murder 1, murder 2, and also equals as a result of a sudden, violent, irresistible passion.
So in other words, malice and provocation are not necessarily mutually exclusive. You could have both. Okay.
Thank you.
Case of State versus Tolbert is hereby submitted.